So the Supreme Court recently denied emergency review in a case that was seeking an immediate block on the state of New York and actually New York City's controversial rifle and shotgun permit requirements. And now things have developed in the lower court because of that denial. So let's break down what is happening. Also, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee makes amazing coffee and they're huge Second Amendment supporters. They have dedicated roasts for various 2A organizations. So not only do you want to get amazing coffee, but if you want to support the 2A cause, you can check them out using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. Now, as I mentioned in the intro, in this video, we're going to be discussing a new case which was seeking immediate Supreme Court intervention, was denied review from the Supreme Court, and now significant developments have happened. And this all involves a case which challenges New York's permit requirements that must be met to possess either a rifle or a shotgun within the city. The case we're going to be talking about in this video is called Schrower versus the City of New York. This case involves a challenge to New York's application process that requires residents of the city to first apply for a permit to be able to acquire rifles and shotguns within the city. One of the major issues with the permit is in fact that it's purely discretionary. It's a meeting of a good cause standard where purely the City of New York, the NYPD, has pure discretion to determine who can actually have access to these permits and then have access to firearms. Now, this emergency application recently went to the Supreme Court, and Justice Sotomayor, who is the justice responsible for reviewing the applications that come out of the Second Circuit, she had control of this. However, she decided to deny the emergency application. But under the Supreme Court's rules, that meant that the plaintiffs here could seek a resubmission of the emergency application to any of the justices on the Supreme Court, and they submitted it to Justice Thomas. And of course, Justice Thomas, being the pro-2A justice that he is, he accepted the emergency application and then submitted it to a full court for consideration. But then the last time we talked about this case, we discussed how ultimately what the Supreme Court did in an order list is they denied the emergency review of this case, and so they denied review to the rifle and shotgun permit scheme that is currently going on within the City of New York. And since then, now this case is in the hands of the Second Circuit Court of Appeals. And after that denial from the Supreme Court, they have held hearings in this case. And now since that denial from the Supreme Court, the Second Circuit has this case back in their hands. They have held oral arguments in this case. They've had a hearing. And now some very interesting developments have happened out of that hearing. The City of New York was arguing in that hearing that this case is now moot, that the appeal is moot, that the permanent injunction that was placed by the district court against the rifle and permit scheme is now moot, should be removed. And it's very interesting to see now also some of the requests for additional briefings that have happened out of the Second Circuit. Now, this case here was brought by plaintiff Joseph Schrower, who challenges the constitutionality of New York City's discretionary licensing scheme for the purchase and possession of various rifles and shotguns. And on review, the district court in fact granted a permanent injunction against the provisions of the licensing scheme and ruled in Mr. Schrower's favor. Now, of course, that was a huge win, but of course, the City of New York was not going to let that stand, so they appealed up to the Second Circuit Court of Appeals. And oral arguments happened recently, and out of those oral arguments, some very interesting things developed. One of the new arguments from the City of New York is essentially that this appeal and the permanent injunction that was issued by the lower court is now moot, and it should ultimately be removed because it is moot. And they also argue that the plaintiffs here do not have standing to even bring the lawsuit, and that also makes what happened with the permanent injunction invalid. Now, the main argument about why this issue is now moot, why the appeal is moot, and why the permanent injunction should be removed is effectively because the argument here from the City of New York is that Joseph Schrower originally filed this lawsuit back in 2019, and it was against the laws that were in place back in 2019 and the enforcement because of the prior concealed carry laws in New York. Now, as you're aware, after Bruen, in 2022, what ended up happening is there was a broad change in the City of New York and also the State of New York's laws in regards to concealed carry because of the Bruen decision. And then you had the State of New York pass the Concealed Carry Improvement Act, or the CCIA, and it changed some of their laws in New York, actually changed a lot of their permit laws, and kind of made things even more drastic than what existed prior. But it also changed some of the good moral character requirements. Essentially, in some ways, they got rid of good moral character, but really not. It just kind of took a new form. So the argument here from the City of New York is that Joseph Schrower here brought a lawsuit back in 2019 against the old regime of laws, and he was denied the application and the permit under the old regime of laws. And ultimately, what ended up happening is after Bruen happened and the laws changed, Joseph Schrower then reapplied under the new scheme and was given a permit. So now he has a permit to acquire rifles and shotguns. And so the city of New York here is arguing, well, that is the relief that he wanted. And so this whole issue is now moot. Now, like I also mentioned, they argue he does not have standing because the original lawsuit that he filed was against the old New York statute, but not against the CCIA, and the CCIA passed after, and so he would have to bring a new challenge to this. Now, there was some back and forth from some of the judges on this panel in the Second Circuit. One of the judges didn't really buy that argument, with saying, no, the structure has stayed fairly similar. The code section has not changed. Maybe some of the language has changed, but it's still broadly a challenge to the same thing. Two of the other judges, I think, were in favor of the city of New York. And there were also a lot of posturing and positions from the city of New York trying to skew this, to give the judges here an easy out, to essentially give them a way to rule on mootness without actually having to address any of the constitutional issues. They were saying, here you could just say this whole issue is moot, this appeal is moot, the permanent injunction is moot, and you wouldn't even have to grapple with Bruen, the Second Amendment, or constitutionality. And oftentimes, like we've talked about here on the channel, judges love that. If they can punt an issue and not have to address the hard issues, Second Amendment, applied Bruen, historical analysis, any of that, if they can completely avoid it and punt the issue, judges love that. And that's what the city of New York was essentially offering on a plate to these judges. Now, in contrast, the Pro 2A side here argues that the permanent injunction from the lower court should not be vacated. It should not be removed based on mootness, that they have standing here, that this is a constitutional challenge. And the injury here is not just about the permit process itself or getting a permit, but facially, this is a challenge to the validity of the permit process, also under Bruen, and that constitutional harms are enough for an injury. And then also they argue that, under the facial challenge here, they are still able to do this. And they also argue that, let's say the permanent injunction is vacated by the Court of Appeals here, it's sent back down. Nothing stops the city of New York from all of a sudden pulling Mr. Schrower's permit process, or when he goes to renew it, denying him. And then it would lead to this merry-go-round where the judges are saying, well, you could just bring a new challenge if you're denied in the future. Well, he could bring a challenge in the future again, get all the way up to the Second Circuit Court of Appeals once again, and then all of a sudden the city of New York could grant him his permit again like they did here, and then say, okay, this issue's moot, and then send it back down, and you can see how it can lead to this merry-go-round. And there's a lot of precedent in various circuit courts and this circuit court as well that says, that risk of this whole merry-go-round of the legal process is enough to keep the permanent injunction in place. And finally, one of the things I want to point out that came from this oral argument is this whole issue about facial challenges, and how if the government here, if the city here can show that it is constitutional in some application, at least one application, well, then the facial challenge fails. Now, this is also something that was brought up in Rahimi and was part of the Rahimi decision, and about why the whole federal domestic violence restraining order on the possession of firearms and ammunition, why that was upheld, and specifically under the facial challenge, because there was some single application where it could be deemed constitutional, and that's enough to defeat a facial challenge. And that's also what some of the judges here were referencing. Now, this argument happened, I believe, right before Rahimi was issued, and so I would also see some of that bleeding in. And I think that's also why you're seeing some of the requests for additional briefs on this whole mootness issue. The Second Circuit has requested additional briefs on whether or not this whole appeal is moot, whether the permanent injunction is now moot, and whether or not that decision from the lower court should be completely vacated. So if you were to ask my general takeaway of what's going to happen with this whole Schrower case, with the rifle and shotgun permit issue in New York, after the Supreme Court denied the emergency application, I think that was kind of a bad sign in general. And then now you have the Second Circuit, who is clearly signaling that they're probably going to take the easy out, find that this issue is now moot, find that the appeal is moot, find that the permanent injunction is moot, maybe even that the plaintiffs here lack standing. But that's currently what's going on. That's what's developed in the Second Circuit after the Supreme Court denied that emergency request, and that's what's happened in the recent hearings. So if anything else develops, if anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.